Dyke Attorney by phone. We're set for a status conference. Mr. Tissot, excuse me. Obviously, well, I was going to say you're new to the case, but I think you're actually old new to the case, or back in the case, however we want to look at it. From your perspective, where are we at?
Well, I just, this morning we filed a motion for summary judgment on the remaining claims. So that's where things are from my perspective. I think the previous attorney, the only thing she told me about today's hearing was that there was some discovery. There were two questions about discovery that she raised with me. One had to do with there was a request for utilities paid by Mr. Byers. So there are no responsive documents. Mr. Byers hasn't been paying utilities because the tenant has been paying utilities. So there's no responsive documents there. Then I think there was also a request for proof of rent payments. And so the tenant has paid by direct deposit, so there isn't really proof of rent payments other than bank statements. But I'm reluctant to release the bank statements. We could redact them, I suppose. But then at the same time, I'm not even sure what it takes some work to do that, and I'm not really sure what the relevance is. Nobody's denying that there is, that the property has been rented. Whether or not the tenant has actually been paying rent is between him and I don't know how. I don't see what the purpose, what the relevance is. But if the court
objection,
then we can redact the bank statements and provide those. And I realize that Mr. Duck hasn't seen the motion for summary judgment, but in Mr. Byers' declaration, it states that the property is being rented to the Mir. So if that was the purpose for the request for the rent payment, again, I wonder if we've accomplished.
objection.
Just a moment, Mr. Dyke. I'll give you an opportunity to respond. Anything else on that issue, Mr.
So those are the only issues as far as discovery that were conveyed to me. I don't know if there's other things. I know that there were some hearings on discovery in the past, and there were some rulings, but the written rulings referred to the transcript, which I haven't had a chance to review. So I'm a little bit behind the eight ball here. But as far as I know, the only two discovery issues were, again, the utilities, and that's, again, no responsive documents, and rent payments, which could be provided with redacted bank statements.
Okay. Mr. Dyke, let me start with the discovery stuff from your...
Your Honor, we're not prepared to deal with that at this time. We have some significant issues that have taken precedence over that.
Some significant issues related to the case?
Yes, sir. Yeah, absolutely.
I'm not sure I understood your answer.
Absolutely, yes. They pertain to the case.
Okay. Then I guess my question would be to you is what do you intend to take as your next step to address these considerable issues you just referenced?
Your Honor, to touch on where we're at with discovery, we have 4 motions to compel ready and 3 discovery requests ready. We were going to submit those until we received a substitution of counsel paper. However, from the substitution of counsel paper, it is clear that the plaintiff or his attorney did not appear at the 919 hearing. And the conduct of Rosa Ostrom at the 919 hearing was unlawful. If you've reviewed the substitution of counsel notice, it states that it was effective immediately as of December 3rd.
September 3rd.
I'm sorry, not December 3rd. September 3rd, this was to be effective. And we did not receive this in the mail until yesterday. And 3 attorneys have said to the court under penalty of perjury that this was effective the 3rd day of September. However, Mrs. Ostrom appeared at a 919 hearing on behalf of supposedly the client. So we have that matter to address.
And how is that issue relevant to what we need to resolve in the case?
We're not accepting Mr. Tissot as a legitimate attorney for this case, and our step will be to move to dismiss him for violations of Oregon rules of professional conduct. So since we recently found out about this substitution of counsel, we're needing time to respond to that and address problems with that. And there are many other, Mr. Tissot claims he hasn't had time, but supposedly as of September 3rd, he was the attorney. He's had since September 3rd almost 2 months to get himself up to speed. And he's claiming like he just doesn't have time. I have a multitude of discovery requests I've already submitted that I have not conferred on. As the conferrals with the other attorneys have been extremely unpleasant for all involved, I am reluctant to engage in discovery conferrals with Mr. Tissot until the legitimacy of his counsel is settled.
So it sounds like you have a variety of motions you intend to file.
Absolutely, Your Honor.
Obviously, we'll need to address those as they are filed. I don't see the motion for summary judgment, Mr. Tissot, but it was just filed this morning.
I don't see it either. Let me go to the computer, and I can see if there's a record of that.
Hey, if you'd let me... So, as I was saying, I don't see it on the file yet. It's likely in staff's queue and just hasn't been posted. Obviously, we'll need to deal with that. There are timelines for outlining that. I think at this point, what makes the most sense is to wait until the various documents related to the summary judgment are filed and or Mr. Dyke's motions are filed to schedule appropriate hearings to deal with all of those in the normal course rather than set another status conference at this point.
Your Honor, we believe it is unfair and unjust to allow the plaintiff to proceed with any more motions for summary judgment while he has protested and resisted our valid discovery requests. We are wanting to file our own motion. We want to reserve an opportunity to come to decide if we want to file our own motion for summary judgment. And I have explained before, I'd like to do that after the discovery is complete and after we depose the plaintiff.
And you're welcome to do any and all of those things, Mr. Dyke. Case has been going on for 15, 16 months now. There aren't any motions currently pending other than apparently this motion for summary judgment. If you believe there continue to be discovery issues,
absolutely,
you need to file those motions, and we'll address them.
We are reluctant to have to file them to Mr. Tissot.
Well, at this point, while I can, I guess, understand your reluctance, it's the only way they're going to get addressed.
Have you read the notice of attorney withdrawal and substitution?
I do see that. Yes.
You see that 3 parties signed that this was effective September 3rd.
I see that.
And we did not receive this till yesterday. So how can you compel us to proceed with discovery when we have this new problematic matter to deal with?
How does this, the notice of substitution, delay?
Well, now I have to go back to the 919 and appeal that everything it addressed in that hearing is settled in our favor because the plaintiff nor his legitimate attorney were not present. The plaintiff failed to appear at the 919 hearing.
I'm not sure I follow your argument there, but
Your Honor, this was effective apparently September 3rd. Mr. Tissot was not at the 919 hearing, nor was the plaintiff.
So, Your Honor, from my perspective, the substitution is effective when it was filed. Looks like that was a typo as far as the
Objection.
date of effectiveness. So if that just removes the issue, then we'll just make it effective when it was filed, which I think is what was intended.
Objection. 3 parties had an opportunity to see what date was on the document.
And again, Mr. Dyke, I'm happy to address these issues if they're appropriately raised in a motion.
We've expressed that we intend to do that.
And you're welcome to, which is what I've invited you to do, which is what I've suggested that you do so that we can address them. Until that happens, there's really nothing I can do about it.
I understand. Well, I think you have the power to put some of the discovery on hold until this is addressed.
Again, without a motion, I don't. And I'm happy to consider your motion when you file it, and Mr. Tissot's had an opportunity to respond, as all of that is outlined in the various rules. So at this point, go ahead, Mr. Tissot, you had something else?
So I've had very unpleasant conversations with Mr. Duck in the past, and he's been trespassed from my office and told that if he wants to communicate with me, it needs to be done by letter or email. So I would propose to the court that we could confer in writing rather than by phone.
I don't have any issue with that. It might work best for everybody if that's how the conferrals take place. Given the difficulties that we've had so far, that actually might make things a little easier for me to figure out in the long run when I can refer to the letters or emails regarding the conferral, what was discussed and what was requested.
Your Honor, how about you exempt us from conferral for discovery matters? It's proven to be only a waste of time and contention so far.
I don't really have the authority to do that. The UTCR requires the conferral, and
okay.
If it's not a conferral, it requires me to deny the motion.
Well, maybe me and Mr. Tissot can arrive at a minimal, least disruptive conferral format.
I would hope so, and I would hope that you both go into those conferrals with an open mind and an attempt to resolve the discovery issues without needing to file a motion. That's what they're intended to do. Obviously, it doesn't always work, not only in this case, but a lot of cases. That's just the way these things go. But frequently, it does resolve the issue and doesn't necessitate a motion and speeds things along. Again, what I'll propose is that we ultimately get hearings scheduled once these motions are filed. It sounds like we already have the motion for summary judgment on file. We'll look forward to the responses to that, as well as the other motions Mr. Dykes indicated he intends to file. Other than that, I don't think there's anything else we need to address today.
Your Honor, I don't think it's fair to restart all the discovery stuff just because there's been a change of counsel. That's effectively what happened when Rosa substituted in.
I'm not suggesting we're restarting any sort of discovery.
Well, Rosa came in and said, I'm working on this, and this is long after Tamara had time to work on stuff.
And again, we're not restarting discovery. You've got the discovery you've received. If there's anything outstanding, you're certainly entitled to file motions and address that if you're unable to resolve it through a conferral. We're certainly not going back to square one by any stretch of the imagination. All right, we'll look forward to the responses and those motions. Let you both go. Thank you very much.